I am Tomi Daniel, as you all know, and you're welcome to another episode of Tomi Talks Legal. Kindly subscribe to my YouTube channel, click on the like button, and share generously with your audience. So today we'll be treating a very interesting topic, which was actually a product of a client's question. You know, someone just chatted me up on WhatsApp and said, what's your thoughts about this? And I felt it would just be good not to just answer this person alone, but also to put it out there for people to learn, for people to know, for people to, it will guide people in making decisions from ongoing. In as much as they come across this video, it will guide their decision making. So I'll be reading this scenario before I move forward to discuss our topic for today, because our topic for today will actually answer this question in this scenario. So kindly follow me as I read on. So it says, what's your thought about this? My husband and I got married almost 13 years ago, but all our efforts to have children proved abortive. My husband was a civil servant, while I am a senior staff in multinational company. My take-home pay was more than double the salary of my husband earned as a civil servant. This disparity about our salary created no problem because of the love, respect, and submission I had for my husband. About 4 years after our wedding, I was promoted and paid some month's salary increment arrears. I suggested to my husband that we should use the money to buy a parcel of land for property development. My husband agreed with me, but he suggested that we buy the land in the name of the child we were awaiting on the Lord to receive. I saw this as a practical step of faith that would possibly accelerate the answer to our prayers for a covenant child. About 2 years later, I bought 2 other properties, which, in line with my husband's advice, were also documented in the name of our expected child. Almost a year ago, tragedy struck when my husband died in a motor accident. But more tragedy awaited me as we prepared for his funeral. During the funeral, a young woman showed up by the graveside with 3 children, which she claimed she bore for my husband. When I asked for the name of the first child, a boy who was about 8 years old, I was shocked when I discovered that it was the very name that my husband suggested that we used to buy the lands and build the houses. About 3 months after the death of my husband, his family came to demand for the property documents, claiming that the lands and houses belonged to their son because he bought them in the name of his son, whose name is on the documents. And I thought to myself, it was a planned work. What advice do you have for me? When I looked at the reality of this question that was posed to me, in as much as it looks like a real life story, I doubt the reality. But I've come to realize we all have this popular saying that love is blind, but marriage will definitely make you see. Marriage will open your eyes. And we all know that in our today's society, a lot of these kind of funny things happen. And that is why I decided to, detach my emotions from whatever this is as a woman or as a lady and answer it from the perspective of law. In reality, if you were to look at this, I would ask, can a minor actually own a property in Nigeria? What is the validity how possible is it that a boy of 8-year-old will own a property in Nigeria? I would say no. Under the Nigerian law, under the Land Use Act 2004, there is no way a minor would own a property in Nigeria or be granted or be assigned a property. Now, when you look at the Lagos State Land Use, when you look at the Land Use Act rather of 2004, it expressly states the conditions in which a minor can own a property. And I would like to read this out before I go to dissect the issues in this scenario that we have read. Now, number one, Land Use Act 2004, Section 7 states, "It shall not be lawful for the governor to grant a statutory right of occupancy or consent to the assignment or subletting of a statutory right of occupancy to a person under the age of 21 years old." So which means if you're not up to the age of 21 years old, you cannot legally own a property in Nigeria. However, we know that to every general rule, there is always an exception. And I'm going to read the exceptions to you where a minor can have a property or own a property in Nigeria. And here are the exceptions. Subsection A says, where a guardian or trustee or of a person under the age of 21 years old has been duly appointed for such purpose. Okay, which means where a guardian or trustee of a person under the age of 21 years has been duly appointed for such purpose, the governor may grant or consent to the assignment or subletting of a statutory right of occupancy to such guardian or trustee on behalf of such person under age. Then another way a minor can own a property in Nigeria. A person under the age of 21 years upon whom a statutory right of occupancy devolves on the death of the older shall have the same liabilities and obligations under and in respect of his right of occupancy as if he were of full age, notwithstanding the fact that no guardian or trustee has been appointed for him. Now, this means that if a property is owned by someone's mother or father, and at the end of the day they die, the property automatically becomes the title, or how I put it, the ownership of the property automatically devolves on the children, and they will be able to exercise full rights on it. But we are going to go to Section A, which is our point of concern in relation to this scenario, which means that this boy of 8 years old cannot have the title documents to those property in his name. Why? Because he is a minor. He is not yet up to the age of 21 years old. So, peradventure, let us now assume that things were done properly. A lawyer was brought into the picture, to actually draft the documents of trust, for this child. Because this child cannot own this property or cannot have his or her name inscribed on the title documents because he is not yet of age, which means that who are the guardians or the trustee in this circumstance for the child? Now, since a husband and a wife is involved, it means that the parents automatically, have the documents or the title documents in their name, holding in trust for this acclaimed, expected child. Now, if the man and the woman, or the husband and the wife, are holding this property in trust for the child, it means that at that age of 8 years old, no member of the family can come and claim possession of that property. For that to happen, that child has to attain the age of 21 years old. So which means that this widow in question in this scenario has a window period, for which that child to attain 21 before they can contest the ownership of that property, or that boy can contest the ownership of that property. This scenario can only happen if all things are being equal, which means the documents are properly prepared, the right details have been slotted in. Now, if this actually happens, it is actually at the discretion of the court whether and how good the lawyer of this widow is. Now, if the lawyer is not knowledgeable enough, witty enough, investigating enough, it may be difficult to get judgment for this widow, or judgment that would favor her in totality, which means that judgment that would make sure that all the property does not in any way go to that child. So if all things being equal, this is completely going to be at the discretion of the judge, depending on how good this widow's lawyer is. Now, this brings me to the point where I say, what do you do? What are the things you need to put in place, either as a man or a woman who intends to buy property or do investments or create investments together as a couple? There's nothing wrong with you as a man wanting to create investments with your wife, own joint investments with your wife, or a wife wanting to own joint investments with your husband. There is nothing wrong in it, but I would say at every point in time when you're making a decision, get a lawyer for everything. Because at some point, peradventure, if things falls apart, your lawyer, without any emotional attachment, would have done due diligence in safeguarding and protecting your interests. So as a person, as a man, as a husband, as a wife, what are those things you need to put in place before considering, creating an investment or buying a property together with your spouse? Number one, I would say that make sure it is even obsolete now for a property or a document to be prepared in the name of Mr. and Mrs. Tosin. It is no longer acceptable in law. Where that error occurs, the property automatically becomes that of the man. So in this situation, make sure that on that title document, for every document evidencing the purchase of the property or ownership of the property, you as a man, you have your name written on it as Mr. Tosin Shokeye and Mr. Sulaiman and Mrs. Sulaiman Shokeye, so that this shows that both of you have equal rights, equal ownership, equal liabilities to this property in question. Now, this safeguards your interest. Peradventure things fall out and parties want to go their separate ways. It is easy for both of you to come to an agreement that, okay, we are selling this property and we are going to split the revenue or remuneration or whatever the purchase value of this property into two equal halves, and both parties go their separate ways. So nobody is losing. Now, if you're going to be buying properties for your children, in consideration of this scenario, I would advise, make sure that the names of your children are properly stated. Peradventure, looking at this scenario, if this woman has said, Okay, in as much as we are expecting a child and we are going to be creating a trust document for this child, ensure that your lawyer includes it in the agreement or in that trust that this child is yet to be born, so that nobody comes along the line bearing that same name as it happened to this woman. This will be put into contemplation whenever this title document or this agreement or this trust document is being read. Now, let us now assume that you were creating it for your children, their children existing. Make sure that the names and the ages of those children, as at the time that document is being prepared, is there. So I usually do this for my clients. Ensure that whenever you're preparing a document or an agreement or a contract, whatever this document is, ensure that there is precision with your details. There is nothing as over detailing. Ensure there's precision, there is certainty, as this is what will protect you. Ensure that the future is projected in such documents, so that whatever happens in the future, when this document is being interpreted, there will be no form of ambiguity. So as husbands and wives, man and woman, put this in eye contemplation whenever you want to go into joint investments with your partners. If today's episode has been enlightening enough, like I said before, click on the YouTube channel, subscribe rather to my YouTube channel, click on the like button and share generously with your audience as we meet next week. Thank you.